Good afternoon and welcome to today's web conversation on challenges in IT law and governance. I'm Ted Parson. I'm a professor here at UCLA School of Law, where among other jobs, I lead the AI Pulse project, which examines the legal and policy implications of AI and related technologies. Now, today we are delighted to welcome Congressman Ro Khanna, but he hasn't quite joined us yet. So because I suspect there are time limits at both the front and back end, I'm actually going to introduce the proceedings. And and I have a message from Ro's assistant. He's going to be on right now. So I'll start the introductions and then we will be able to speak with Congressman Khanna as soon as he joins us. So I'm here with my colleague, Eugene Volokh, who is Professor Gary T. Schwartz Professor of Law at the UCLA School of Law. Eugene is an expert on the First Amendment, but he has wide-ranging interests over many areas of law and a prolific scholarly record. He's a member of the American Law Institute and a well-known legal blogger on his blog, The Volokh Conspiracy. I've received notification that Congressman Khanna is joining us any second. And so I'll actually go ahead and begin introducing him before he's physically with us and say, we're delighted to welcome Congressman Ro Khanna, who is a leading progressive thinker on law and technology in the United States Congress. Ro represents California's 17th district in the U.S. House of Representatives, where he chairs the Environmental Subcommittee of the Oversight and Reform Committee, and also serves as Deputy Whip of the Congressional Progressive Caucus. He has wide-ranging interests and expertise in technology issues, including authoring a couple of years ago, at the request of Speaker Pelosi, a widely praised set of principles for an Internet Bill of Rights. He's also a passionate advocate of using technology to bring economic opportunity to rural and small-town America. Welcome, Congressman Khanna. Do you prefer being addressed as Congressman Khanna or Ro? And you are muted.
Sorry, I'm a few minutes late. Ro is great.
Oh, terrific. Okay. I actually presumed your imminent arrival and I started to introduce the proceedings and you in your absence.
Right.
So I've been 60 seconds singing your praises.
I'm glad I missed that. The introductions are always too long and over the top. So
well, mine were short already and I have only 2 sentences left.
Good.
So I've already told our viewers how you're a passionate advocate of an expert on a wide range of technology and law issues and an advocate of using tech to bring opportunity to rural and small town America. Right. Prior to serving in Congress, Ro worked as an intellectual property lawyer and served in the Obama administration as Deputy Assistant Secretary of Commerce. He holds an undergrad degree in economics from the University of Chicago and a JD from Yale. I believe you know my colleague, Eugene Volokh, whom I've already introduced.
Oh, he's been terrific. He's helped me so much on thinking through these issues. We don't always agree, but he's really helped shape my thinking.
I was actually very intrigued by the fact that you two obviously have a constructive relationship, because I have grounds to believe there are a number of issues on which you might disagree. Here's how we're going to proceed today. We have 60 minutes in total. Eugene and I will lead off posing some questions to you, Ro. We have a group of participants online. The numbers are fluctuating, going up. We have about 30 at present. The Q&A will be open over Zoom. After about 20 or 30 minutes, I'll start feeding in questions from the Q&A as they are relevant to our ongoing discussion. And I'll wrap us up promptly at 3 p.m. Pacific after 60 minutes. So, Ro, I had some challenges in preparing for today because you have such wide-ranging interests. It's challenging to figure out what to talk about in 60 minutes. And I want to put a flag up for a future conversation. I'd love to engage you on environment and climate change issues, but today our subject is technology. And even within the space of technology, you've worked and written on content moderation and free speech and consumer data rights and privacy, market power and antitrust law, and online democratic deliberation. Now, I expect Eugene is going to want to dig in deep on First Amendment, free speech, data, and privacy issues. But so I'm going to take a first bite and pose you one question about antitrust before we go there, which is, I'm struck, you've suggested the possibility that effective regulations to protect consumers' online data rights might lead to a restructuring of digital markets, including social media markets, to create a more competitive environment including multiple social media sites and, even the possibility of a public option, a kind of a CBC or BBC of social media. And I just wondered how confidently you can hold that view given the powerful kind of natural monopoly structure that applies in the presence of such huge network externalities and economies of scope.
It's a very good question. And there are definitely network effects. And one of the criticisms of saying, well, if you have more competition, aren't you going to actually lead to a further fragmentation of public discourse? Because if you have 10 different social media sites, is to say, no, actually, you're probably going to still have 3 or 4 social media sites be leading. And the reason is, unlike television, most people don't want to be on 15 different social media sites. The question, though, is if you have greater competition in some ways and greater data portability, could you have more people do what Jack Dorsey is saying? Where Dorsey is now saying, well, let me give people a choice of different algorithms to see social media. Let me be more creative about data privacy. And let me be more solicitous of consumer input in the rules of communication. My view is on the margins, more competition will push people to do things like what Dorsey is now contemplating in offering people different algorithmic options. And the acquisition of WhatsApp or Instagram, suppressed even the emergence of potential competition. So it's not that I foresee that there's going to be a market of 10 or 15 different social media sites, but if you have a publicly backed option and if you have stronger rules against mergers, just changing the default presumption, then maybe you can see a greater competition within social media to not just have a default to the current situation.
Just more effective enforcement of current antitrust law, or something new in antitrust doctrine to address the novelties of the IT and technology space?
Well, I think something new in terms of, I don't know if it's particular to IT, but I agree, for example, with Senator Klobuchar's position that if you have a $100 billion company and a $5 billion deal, that we should change the presumption. So the presumption should be on the company to show that it's not anti-competitive. That would go a long way. And by the way, I saw some data on this, that it only affects 2 to 3% of deals. And those are the deals that over 50% of them are triggering second order reviews anyway. So just changing that presumption, I think, goes a long way. Then I've talked about a standard of having a duty to allow sellers on these platforms. So Amazon and Facebook, we should be suspicious if they're kicking off people from their sites. Now, you can argue, well, Apple was able to do that with Parler. So you can't have, in my view, a blanket duty to allow sellers, and you should have some autonomy over your site. But we could have a greater requirement for that. And then I think having data portability and interoperability, where you have other apps, other companies be able to design things for Facebook, design things for Twitter, or be able to take your friends to other sites. I recognize that there's a tension between that and privacy. The more you allow for interoperability, the more you allow for portability, the more you're risking data privacy. But I think those are the types of things that could create more competition, more challenge for social media.
Thank you.
So I don't have anything to say about antitrust.
Hi, Eugene.
Whoops, I do think my shirt is askew, I just realized. So I don't have anything to say about antitrust, but I do agree about competition. And in fact, I was pleased to see that Parler is back on. We have our site auto-feeding to Parler, and we have about almost 100,000 subscribers there at the Volokh Conspiracy. And one of the reasons that I like it is there needs to be competition. Any business or any governmental entity that has no competition is going to end up shortchanging its customers, even if it's well-intentioned. It's just not going to have the same pressure that that competition produces. So So I do think if we can find ways of doing more, providing more competition, especially through things like interoperability, but also just companies starting up and providing rival services, that's be very, very useful.
We don't have to stay
Well, we
on
start off
antitrust.
on a note of relative agreement. I'm sure Eugene didn't like my call to have Amazon suspend Parler's service up through inauguration, but I too am glad that Parler has a service now, and don't think that they should in any way be permanently suspended. Right. I did think, and this is where we can probably get into it with Eugene, I think that there are cases where temporary measures, where you're coming close to the line of violence are important, but I agree that just censoring Parler and putting them permanently out right. is not healthy.
Yeah, no, so I appreciate the arguments for trying to block certain services that we think they're being used badly. My view is it's kind of like phone service, right? If we have a system where phone companies don't just cancel phone service because somebody we think is using that phone service to plan violence. If we do think that we could get a warrant, maybe we could arrest them, we could prosecute them, but we don't leave it to phone companies to do that. Now that's a matter of common carrier law, and platforms are not common carriers, but it seems to me that that the approach we require of phone companies serve everybody is at least something that we should allow as a matter of social convention as well as law to platforms, that if platforms want to say, we're going to be kind of like the phone company, we're going to be kind of like the post office, where we don't pick and choose whom to carry, or if we do pick and choose, we do it in a very narrow zone, then it seems to me that that's something that's a sensible approach and should be encouraged rather than discouraged.
Well, yeah, there we probably disagree. I mean, I don't think that they're obviously publishers. I mean, I don't think you could have these platforms to the same standard as the New York Times. I mean, they're not sitting there picking out 5 op-eds to publish or a few hundred stories, and they're publishing hundreds of thousands of posts. But it seems to me that there should be some recognition of liability if their sites are being used to traffic in clear plots of assassination, clear plots of violence. Now, I would require the court order and look at things that have been adjudicated through a court. Of course, in the call of Amazon, that wasn't the government making a call. I mean, you could just say it's Amazon's own free speech rights to say that they don't want to be affiliated with providing service to Parler for a particular duration, and Apple and Google have those free speech rights as well. But I do think that there has to be some line where we would go into violence.
May I pose a couple of questions on privacy? So I had one queued up for you, and there's actually one or two that have come over the wires already. So you've called for a federal data privacy law, and I was going to kind of pitch an open-ended question at you of the form, what would the major elements of that law be? But somebody on the line has already sharpened that question for me. And they've asked, what would you think about using California's law, the CCPA, as a model for federal data privacy law? Do you have worries about a weaker federal law that might preempt stronger state protections? Do you have concerns about the specific elements of the California state law? What do you see as the most promising directions in broad terms?
So I think it's a promising start. I think the challenge with this, as is the challenge with GDPR, if you think that, as I do, that the key should be opt-in consent for data privacy, the challenge is there was a paper out recently that I looked at that said that these tech companies actually are very effective in getting people to consent. So they're by having the graphics be a certain type of color, having the size be a certain place on your screens, having the default of the compliance actually be, I will choose to accept. And in the pop-up that comes up, it turns out that they basically were getting a lot of people's consent. So Well, one of the things I think we have to focus on is actually the enforcement. And people keep citing the EU, but I mean, I read Italy put a $7 million fine on Facebook, and it was almost laughable. And that's not enforcement. That's less of a, it's more, that's about as much of a nuisance for Facebook as maybe getting one parking ticket a year is for most Americans. And so I think that there's not enough effort put on the enforcement, and there's so much effort put on the formulaic of what we want to do and consent or not. And what I would say is, let's have opt-in consent, but then let's hire tech folks at the FTC, FCC to actually figure out how you have consent that is specific, how you have consent that actually empowers users and isn't being subject to the manipulation of these companies.
So I think that there's a lot to be said for having privacy rules that say that if you're a customer of some business, the default should be that the business is going to not publicize what you're doing with it, because that's what a lot of customers expect. At the same time, a lot of the rules, including in some measure, I think the CCPA and famously the European rules as well, aren't limited to transactions between the business and its customers, but in principle apply to, for example, newspapers. And that's why there is a sort of right to be forgotten, which is really a right to require newspapers and other places to scrub their archives. In principle, if you really take seriously the logic that someone owns information about themselves, that means that you could require a book publisher to withdraw a book and redact it to remove information in the book about somebody. There already are cases where convicted criminals in Europe have gotten orders requiring newspapers to remove their stories from historical archives. On top of that, law firms, right? Many of the people in the audience here are going to be lawyers. Law firms investigate all the time, including people who don't agree to be investigated as part of their professional services. So if you give people really, for example, even a right to demand that any business reveal what's in their files on it, well, then if somebody is suing me, I can go to the law firm and say, well, turn over everything in your files, including all of these potentially confidential bits of research that you've done about me. So it seems to me that some of the rhetoric of privacy strikes me as quite excessive. Again, the notion that we own information about ourselves. Information about us is kept in other people's minds. And to own information about ourselves means to stop other people from talking about us, perhaps from thinking about us, from the right to be forgotten is a right that is aimed at trying to get other people to forget and not to be able to refresh their recollection. So I think that there is a peril in some of these privacy rules that needs to be dealt with. Just to give one other example, it's a different kind of privacy, but an instance of the dark side of privacy. There used to be a lot of attempts, many quite successful by police officers, to stop people from recording them, because on the theory that there are these state privacy laws that prohibit recording people without their consent. And courts in recent years have said, no, there's a First Amendment right to record police officers in public places. But I think but again, if you really take seriously the notion that everybody owns information about themselves, well, then yes, even a government employee would be able to stop others from recording certain information about what they're saying and doing. So that's the reason I'm something of a privacy skeptic, but I agree that certain kinds of privacy rules make lots of sense.
So I would say, I agree with Eugene on the right to be forgotten. I think that would contradict our First Amendment jurisprudence. Every American politician would want things about themselves forgotten, and we'd have multiple requests to scrub the internet. And so I also agree that
who was it who just went to Cancun? Sorry.
And I also think that there is some part of data that is social, right? I mean, when I walk into a store, forget the internet, I give information about where I live often. I give information about my name. I mean, that's a public information. But the difference, I think, and this is and how we construct the laws, I think matter, is what bothers me is the use of information for the construction of profiles that target for monetization. And so when you're giving thousands of data points that aren't about, let's just have this in the public domain of public debate, and for speech or for a public-oriented purpose, but are being used by companies to really target advertisements at people or target content at people. That's where I think having opt-in consent is necessary.
Although it sounds like Eugene's concerns go further than being effectively addressed by opt-in consent. So I'm kind of wondering, where's the boundary here? So is the essence of your concern, Ro, in the commercial exploitation of individual data? Is it in some consequence of the aggregation and the analysis of data about huge numbers of us and of our behavior?
The essence of my concern is the commercial exploitation and or the government exploitation of data. Now, you know, I mean, for example, there is a study out that Facebook, that 64% of people who joined QAnon on Facebook actually received an affirmative recommendation, both based on their social media profile to do that. Now, you could argue, there was a fascinating study I read that showed that even if individuals don't give consent, Facebook largely will have enough data out there aggregated that they'll be able to construct social media profiles and probably be able to do a lot of that targeting anyway. And so that actually is a counter to my argument that sort of opt-in consent is going to solve all of these things. But I do think that there's such cynicism about the public sphere and communication that I think giving people a sense that they are not being manipulated online and that their data isn't being used to target them increases the trust in our conversations in these sites as public forums. And at bare minimum, I think the opt-in consent serves that purpose. And it probably also makes the value of targeting profiles probably a little harder. I mean, so it reduces the value of that. And that's why I think it's encouraging.
Yeah. Yeah, I think we all agree on the value of opt-in consent. I mean, this is a point where, you know, the three of us perhaps don't agree on a lot of things, but I think we do. I think we're arguing about how effectively opt-in consent alone would advance the interests that you're concerned with, and how much sort of risk or impairment of other values might be implicated by moving beyond it.
Well, can I follow up on that a little bit? Because if the concern is individual targeting, that somebody's using your profile to target you for certain things, I'm not sure what's so awful about that. My sense is, and you know, Ro, you know so much more about this because this is your job, but my sense is that a politician who doesn't micro-target his message to the extent possible is kind of a fool, right? If you say the same thing to the farmers in your district, I don't know if you have farmers in your district, but that's some hypothetical yours, as you do to the tech workers, they're going to say, why is he talking to me about these things? I'm not that interested in that. Likewise, I imagine a good salesman gathers whatever information he has about someone, maybe drawing inference about how they dress, how they speak, what they look like, to say, oh, you know, if he sees somebody with a wedding ring, maybe accompanied by a wife and a couple of children, he'll pitch the message one way. Whereas if he sees someone who looks younger and looks like he's looking for something more sporty, he'll pitch a message another way. And it's a manipulation, I suppose, but a lot of constitutionally protected and generally not terribly troublesome persuasion is a form of manipulation in that you're trying to figure out where a person is open to persuasion and persuading them that way. So what exactly is so bad about micro-targeting either political messages or commercial messages, especially given that this is what we've been doing when we've had the opportunity to, and often in our own kind of retail as opposed to wholesale persuasion, we do have the opportunity to. We've been doing it for millennia.
Well, but and I'm not extreme on the view of some people saying, okay, let's just ban all targeted advertising, because I do think that, you know, I don't mind if a florist is showing me the ads, if Facebook is showing me the ads for the florist near California, near where I live, as opposed to showing me ads for florists in Chicago or Washington, D.C. And I think there is a value in some targeted advertisement, and particularly value for small businesses in targeted advertising, a value for newspapers in targeted advertising. I guess the question is, do people with all of the excessive levels of data we have, which is an ability to do things with much greater precision and much greater manipulation than in the past, one, is there a sense of a loss of agency? And my data is being used by, let's just say the Trump campaign, though you could think the Bernie campaign, in ways that are aiding that campaign to suppress the vote somewhere or convince someone. Should I not have some ability to at least consent or opt out of that? Why should my information be used for an end that I don't want to support? And secondly, if I'm being manipulated in ways that are beyond, okay, buy from a florist, but actually feeding me information that may be the most sensational, that may be the most provocative, at least I should be aware of what type of manipulation is taking place, what I'm being sent to. So it's not that I would ban it, as some people want to do. It's not even that I would necessarily regulate the targeting. All I'm saying is, how do we lose if there's more transparency and choice, where I should have the awareness of what's being done to me?
It sounds a little like just nutritional labels, disclosure requirements. Yeah, with the plus and the minus that comes with that. We have a question that's come in actually through the chat.
This is not product placement.
And actually, let me ask others who want to send questions, please use the Q&A, not the chat. But this one I've caught off the chat. Someone asked, could the government prohibit a platform like Twitter from blocking or declining to host an individual's content or account without violating the platform's own speech or associated First Amendment rights?
So, for example, could the government tell Twitter not to host Donald Trump? Is that the question?
No, other way around. Could the government
prohibit
Twitter,
that's right, prohibit Twitter from barring Donald Trump. Yeah.
Could it say, Twitter, you're like a phone company. You're a common carrier.
You have to serve everyone.
Carry everybody.
I'd say
subject to view, or at least in a viewpoint neutral way.
So I mean, Eugene may know more about the doctrinal aspect of it. It seems to me that the government would be violating Twitter's rights of defining their own identity if we told them that you had to carry certain speech on their platforms. I mean, I suppose you could treat them as what would you treat them as a public utility or a common carrier where they had to do things, and then the government would then be involved in defining those standards of what was acceptable or not. But I don't know if we want the government making those determinations. But Eugene, I would like to hear your perspective.
So I think as a policy matter, I think there's a lot to be said for the government not intruding here, just among other things, because the government tries to do these things, there are always going to be unintended consequences. I'm not sure what's right as a policy matter. I've come around to the view that it would not be unconstitutional. So it would be constitutionally permissible for the government to impose such a regime. And basically, the one question is Twitter more like a newspaper or a bookstore, which does have a First Amendment right to select what appears in its pages or on its shelves? Or is it more like a phone company, which does not have such a First Amendment right? And the cases, I think, suggest it's more like the phone company. So the three key cases that I think are most on point are Pruneyard, which says that the state of California could require shopping mall owners to allow all leafletters on their property, large shopping mall owners, all leafletters on their property, even if they disagree with the message in the leafletters. They don't have a First Amendment right to exclude people from their property because of those people's speech. It may have been the wrong decision, but that's pretty well settled. Then it was adapted in 1994. That's a decision from, I think, 1980. It was adapted in 1994 to cable operators. So cable operators, cable systems, were required to carry broadcasters. This, in fact, was called a must-carry regime. And the court, by a 5-4 vote, said that does not violate the cable operator's First Amendment rights. Now, There were 4 dissenters, interestingly, Justices O'Connor, Ginsburg, Scalia, and Thomas, an interesting mix. But the majority said it's permissible to require that. And it seems to me that Twitter's relationship to its users are pretty similar, not identical, of course, but pretty similar to cable systems' relationship to the channels it carries. And then the last case, unanimous, Rumsfeld v. Fair, which held that the government could require universities to allow military recruiters on their property. The court unanimously said that would be permissible, even if it were implemented as a categorical mandate. That law actually said it was a condition of government funding, but the Supreme Court said it doesn't matter if it's a condition of government funding. If the government wanted to just mandate that every university allow recruiters on its property, that wouldn't violate the university's First Amendment rights. Those, I think, are pretty powerful precedents in favor of the constitutionality of a common carrier rule. Now, note, I think in any event, Twitter would have a right to decide what to promote. So it may say we won't actually affirmatively push out certain things as our promotion. It would have a First Amendment right to say, we're going to put a disclaimer for these tweets or any tweets from this account saying, we don't trust this and you shouldn't either. That would be Twitter's own speech. But when it comes to Twitter's right to block things from its property, much as I respect that as a property rights claim, I just don't think that the Supreme Court's current First Amendment jurisprudence recognizes such a right to reject reject speakers from your property, given the Pruneyard, Turner Broadcasting, and Rumsfeld decisions. And by the way, I should say, Erwin Chemerinsky, if you look at somebody who in many ways is very much on the other side of a lot of constitutional issues from me, just had an op-ed together with a colleague of his from Berkeley in The Hill saying pretty much the same thing, just 2 days ago.
That Twitter should be required under this to carry basically Donald Trump's account.
Well, right. I think he may have actually said that it should be required. I think he was making a policy argument. But at the very least, he said that it could be so required. And I'm sorry, this was actually from yesterday. It's by Prasad Krishnamurthy and Erwin Chemerinsky. I will post a link in the chat. I think I'm allowed to do that, right? So I'll post a link in the chat.
We all have access to the chat. Yeah.
His position is that that would be constitutional.
Yeah.
No, I'd have to read it.
Yeah, feel free to respond. I want to bring us back to privacy, but I want to give you a chance to respond first, Ro.
I would have to read it. It strikes me as a stretch to argue that these are common carrier platforms as opposed to platforms that are making editorial judgments. So there's a sense where there's a lot of communication on the internet that one could have. So I would say that an internet service provider that actually restricts or allows our access to the internet is something that is more analogous to a common carrier. Whereas I would argue that that a Twitter or a Facebook are creating and organizing the content. They're not fundamentally saying whether we can participate in communication on the internet or not. I'm not familiar enough with common carrier law to know whether they would qualify as a common carrier or not.
Yeah. Eugene, somebody in the Q&A has just posted a follow-up question to your remarks that's so precisely on point. I want to pass it on now. They ask, would your conclusion be different if there was a clear identity of a platform, a clear communication in advance that we are a place for this particular kind of views? You know, the Pruneyard shopping mall says, you know, we're a patriotic American conservative shopping mall. And that's so broadly broadcast that everybody understands what Pruneyard is and who goes there. Would that, under your view, confer more liberty upon them to, say, selectively exclude leafleters with politically opposing views, or the corresponding exclusion on the part of an internet platform?
So I think the answer is no, although I appreciate the argument. So why do I say that? So first of all, in Pruneyard, there was some similar position taken by concurring justices, Justices Powell and White, who took the view that essentially, look, if the owner of Pruneyard had said, this really interferes with my own message, that would be unconstitutional. It would be unconstitutional to require them, but that did not enjoy the views of the majority. But on top of that, consider Rumsfeld. What was happening there? Universities were refusing to allow recruiters because of the university's own message, which was pro-gay rights and anti-don't ask, don't tell, which was the rule at the time adopted by the military. So the universities really they weren't anti-military as such, but they were acting out of an opposition to one facet, or one thing that was associated with the military, which was their policy of discriminating based on sexual orientation. Unanimously, the court said, it doesn't matter. Universities remain free to say all they want. They remain free to put up signs saying, we disapprove of what the military is doing, but they have to allow the military there. Now, as it happens, actually, Congress did accommodate religious universities who had traditionally pacifist ideologies. They were exempted by statute, but they were not entitled to a constitutional exemption. And again, a university that might have wanted to announce, we're the pro-gay rights university, we want nothing to do with the military, would not get any constitutional exemption under Rumsfeld v. Fair. So I appreciate the argument. I think it's a powerful argument as a matter of kind of property rights and as a matter of respecting maybe even consumer choice. If there really was a liberal and conservative network, maybe that would be more consumer choice. As a constitutional matter, I just don't think it's consistent with the precedents.
And Eugene, you know more. It's been years since I read Pruneyard, but is that, my understanding was that's an interpretation of the California Constitution. Is it it's not an interpretation of the US Constitution, but I could be misremembering the case.
It's a great question. The answer is it's both. There were two steps in Pruneyard. The first step, so what happened was that the challengers sued Pruneyard, saying, you must allow us on your property. And Pruneyard said, our property. We get to decide who goes on our property.
Right. We're private.
So the first question is, did they have a cause of action under state law in the first place? And the California Supreme Court, I think probably incorrectly, as a matter of interpreting the state constitution, but it's the ultimate interpreter of the state constitution. The California Supreme Court said, yes, under California law, under the California Constitution's free speech provision, you have a right of access to large shopping malls. Most state courts since then have not accepted that, only about half a dozen have. And even the California Supreme Court has ended up reading it quite narrowly. But still, that was a decision as a matter of state law. Then it goes up to the US Supreme Court, because the shopping center says this violates the state law right, supposed right, it violates our federal constitutional rights. It's a taking of our property, and it is a violation of our right not to be compelled, our First Amendment right not to be compelled to host things. And the US Supreme Court said, of course, we don't pass judgment on whether the California court's interpretation of California law is a sound reading of the California Constitution. That's up to state courts to decide. But we say that such a state law rule does not require compensation as a taking under the federal takings clause, and does not violate the right to be free from speech compulsion secured by the First Amendment. So that's why there's both a state law question. Do the leafletters even have a right to just go on this property in the first place? And there's a federal question of whether once that right is recognized by state law, does it violate the First Amendment? And the court said, no, it doesn't violate the First Amendment.
But wouldn't that suggest that the court isn't saying that the students have a First Amendment right to be there? They're saying that if Congress were to pass a law saying that they have the right to be there.
I am totally with you. I don't think that anybody has a First Amendment right of access to Twitter or to Facebook or to YouTube or whatever else, because those are private actors. Just like nobody has a 14th Amendment right to be hired without regard to race or religion or sex. Question is, what happens when the government steps in and says, well, we're going to pass civil rights laws that apply constitution-like rules to private actors, or we're going to pass private right of access laws or common carrier laws that require viewpoint neutrality on the part of a shopping mall. That wasn't technically legislation, but it was seen as an equivalent of legislation, state court decision, or to a cable system, see Turner Broadcasting, or to a private university campus, see Rumsfeld, or to a platform. So it would require legislation, probably federal, at least state legislation, to call them state actors. And the state actors, no, I'm sorry, I'm completely wrong. Call them common carriers. It wouldn't make them state actors. The question is, if they are made common carriers by law, do they have a good First Amendment defense to that, saying, no, you can't make a common carrier, just like you can't make the New York Times a common carrier. And I agree, you can't. And I think the answer is no. If Congress were to decide to make them common carriers, it wouldn't violate the First Amendment.
And why do you think, so I agree with this then, but basically you're saying, with the gist of it, basically you're saying Trump does, I mean, just to put this in a concrete, Trump doesn't have a First Amendment right to go to the Supreme Court and say Twitter was wrong in kicking me off. He would lose. But you're saying if Congress were to pass a law saying you can't just kick off Donald Trump because of his beliefs, that law would pass First Amendment scrutiny, in your view, at the Supreme Court. Now, the question is, why do you view Twitter? Why do you not view Twitter as just sort of organizing content the way the New York Times does, more akin to the New York Times, and AT&T or Verizon more akin, or Comcast more akin to the phone companies? I mean, why is the Twitter sort of fundamental to our participation on the internet?
Right. Well, so I think that's a great question. That would be the question that courts have to reckon with if this comes to court. If there is a statute that's enacted and it's then challenged, and it's very similar to what the court had to deal with Turner Broadcasting, because that's one thing. The Turner Broadcasting, as a cable operator, said was, look, we're kind of like a newspaper, or at least like a bookstore. We curate those channels that we think our subscribers will find most useful. And if that means we prefer some cable channel over the local broadcaster, we should be entitled to do that. Just like a bookstore should be entitled to say, we publish or we sell pro-free market books, but not pro-socialist books, or something along those lines. And the court said, well, one thing we need to consider is, to what extent do people view your offerings as part of a coherent whole? So a newspaper, or especially a magazine, especially clear for a magazine, but also a newspaper, it is a unit of speech, and people often subscribe to a newspaper precisely because of what that newspaper offers. It didn't get into bookstores, but you can say the same thing as well. You can have feminist bookstores, pro-free market bookstores, whatever. On the other, and likewise parades, there was another case that the court had dealt with, or the court actually later dealt with, and it said, look, a parade is something that people view in part, not just individual floats, but the overall theme. But the theory was there's no overall theme to a cable system. A cable channel might have an overall theme. ESPN has an overall theme. BET has an overall theme. But a cable system doesn't have an overall theme. Likewise, the set of all things on offer at a university, including all the recruiters and all the invited speakers and everything else, is not an overall theme, so the university gets to curate essentially the overall experience of being on the university campus. Likewise, a shopping mall doesn't have an overall theme. And likewise, I think Twitter and Facebook, people don't go there saying, I'm going to Facebook because I want to check out what Facebook has. They go to Facebook generally for Facebook pages. They go to YouTube for particular videos. They may search on YouTube for particular videos, but they don't view this experience of YouTube as all of kind of the YouTube stuff put together, the way we view the New Republic or the National Review as kind of an aggregate of all those things. This, of course, requires judgment call.
Yeah, I guess that's an argument for Dorsey and Zuckerberg to embrace more competition and stronger antitrust. The more platforms that emerge and the stronger they have content moderation, the less likely they probably will be held as common carriers.
Yeah, although when we touched
Well,
on this earlier,
I
Ro,
agree.
it
The
seemed to me
political.
you relied rather a lot
Sorry.
upon Dorsey creating a big diverse tent within Twitter, which of course is not quite the same thing as having more competitors to Twitter for consumers to choose among when they're shopping in the social media space.
I agree with that, and that's why I sort of back this idea of some public option for social media. They'll recognize that probably hard to get traction for that, but I think the network effects are so strong that the idea that you're going to have multiple social media, like we watch 10, 20, 30 different channels. I mean, who knows? No one can predict the future. It seems to me unlikely that we're going to be surfing 20 different social media sites. That said, what I don't think is unrealistic is that 5 years from now, Twitter or Facebook are displaced for some new entrant
Right.
that emerges
Right.
that does things more creatively.
And who might grow even bigger.
Yeah, well, I personally don't believe that, because I think that MySpace has such a monopoly over social networks. There's no way it would ever be.
Yeah, I saw your profile on MySpace just last week, Eugene. So I feel like we can't, I mean, this is fabulous. I feel like we can't let the session end without taking some account of what's going on in the world right now, in particular COVID. And so I'd like to steer us back a little toward the privacy questions we were on about 20 minutes ago, and ask you, Ro, about privacy, social media platforms, and public health. So it's really striking that some of the countries that have done the best job in managing the COVID pandemic have done so with an impressive degree of coercive exercise of state authority over communications media and kind of related technologies, and thus over citizens. Whereas in the United States, we've relied more on voluntary measures for contact tracing that have been rolled out by the major providers of mobile operating systems, Google and Apple. Do you think the United States has got it right as a matter of current law and policy, or in the context of big sort of public health emergencies with, strong externalities and risks that people impose on each other, would a more heavy-handed approach toward media companies and through them toward citizens have been more appropriate?
Well, I think we've gotten it right. I think the irony is that other countries have used the Apple and Google software much better than we have. I mean, Ireland used it and Germany used it to great effect. And I think the concern here was not that we needed a greater surveillance the way Singapore had, or South Korea had, or Taiwan had. I just don't think that would fly in the United States, where people were being traced if they left their apartment or houses, or were having their data, if they got COVID, sent to the central government, and officials in some cases were showing up if they were violating the orders of masks or social distancing. I just don't think that would ever fly in this country. And so I support the privacy protections on those apps. The question is, why was it not adopted in the United States? Partly, I think that's because we don't have a privacy framework, and so there wasn't sufficient trust. But I think that goes much deeper, which is that there is a decline of trust in institutions in this nation, whether that is a trust in Congress or government or companies. And how we deal with the decline of trust in institutions, I think, is one of the big questions of our time. It's actually, I think, one of the reasons why the big lie that Trump proposed gained such traction, because I think as an initial matter, people feel, well, all politicians are just going to do what's in their power. So of course, whether it's Donald Trump or if it's a Democrat, they're going to do what's maximally there to have their chances to win. So there's such cynicism that it was not a far step for Trump to say, well, see, they're just manipulating things on their end. And I think what the real question is, why do we have such cynicism and lack of trust in institutions in this country?
So I agree with pretty much everything that Ro says here. Let me just add, there was a story a few months ago about Anthony Fauci saying that basically when he had been asked earlier on in the pandemic how much herd immunity is enough, when will we be kind of done with the lockdowns and such, he used to give lower numbers because that's what he thought the public would be willing to accept. And then as things went up, excuse me, as the pandemic progressed, his estimates got higher and higher, not just because he changed his mind. Of course, you should change your mind when the facts change or when your perception of the facts change, but because he thought that the public was ready to get to accept that. Look, I understand why he'd want to do that, but if you want to point to something that doesn't engender trust, I would think that kind of practice, or perhaps it's the admission of the practice that's the problem. But if that is the practice, then that helps show that people are sensible in not trusting the authorities, even though we'd like them to have trust. Don't the authorities need to be trustworthy in the first place?
I'm grinning because we're moving within an inch of the environment and climate change questions that I promised not to bring
well,
up
there you
today,
go.
because it's about scientists sort of self-filtering their communication of information based on their real scientific expertise, based upon guesses about what the public or other audiences, be it congressional audiences or policymaking audiences, are willing to accept. Because of course it's within a broad zone of uncertainty.
There's Mark Brown is a political scientist, I think, has written a lot about science policy that I think is very thoughtful. And one of the points he makes is our challenge in this country is less a challenge about science as much as it's a challenge about values. Thomas Hobbes had this famous saying once that people would deny that a triangle has three sides if it's in their self-interest. And so often we have this view that let's just surround ourselves with scientists, but there's questions of values at stake, right? One of the values could be how much do you trade off the risk of probabilistic environmental damage versus economic damage, and what are those values? And so I think one of the big challenges for us on the science policy is having much greater democratic conversation and participation in not sort of lecturing people with judgment to get buy-in for climate goals.
Yeah, and not pretending that political or policy questions that have substantial elements of value preference embedded in them are actually scientific questions, right?
That's well said.
Yeah. Science doesn't tell us what to do. I mean, it's like I'm on Greta Thunberg's side, but all those people saying, listen to the scientists and they'll tell you what to do, there's a fundamental kind of categorical error there. Science tells a lot, and a lot of people who resist action are lying about the science, but the science doesn't actually tell us what to do. In the 5 or 6 minutes
as opposed to lawyers, by the way, you should always listen to us.
Yeah.
As opposed to lawyers.
It's true. In the few minutes we have left, there's one question on a topic that hasn't come up yet that's come over the Q&A that's really current and interesting. I'd love to get your views on, Ro and Eugene as well. Someone's asked about the new Australian law requiring social media platforms and content providers to pay for content originators, and asking whether that would be legally and constitutionally permissible or good policy in the context of the United States.
I personally don't think that makes sense in the context of the United States. It seems to me that you would basically be putting a tax on the distribution of content. So if I have an article that is talking, I care very deeply about the human rights catastrophe in Yemen, and if I want that to be broadcast broadly, because CNN isn't going to cover me if I want to go on CNN or MSNBC, it's not clear to me that I wouldn't want Facebook or Twitter to distribute it without having that be taxed for the content generation. Now, I'm open to some kind of tax on digital advertising revenue to support independent journalism or other ways, but on first blush, that doesn't strike me as the best policy.
It does have a disturbing price setting, sort of government price setting character to it, because once you say you have to pay for it, the question is who says how much you have to pay for it?
So I think that's right. One question that this raises is how we should treat this under copyright law, right? So generally speaking, the way we assure content providers of some return on their investment and encourage them to provide more investment is give them exclusive rights under copyright law. And to what extent should, let's say, Facebook's allowing the passing along of links be viewed as a copyright infringement. Under American copyright law, I don't think it would be, although distributing snippets might be more that. But you could imagine different kinds of intellectual property-ish regimes that aim to make sure that that content providers are compensated. And one possibility, of course, is they could just set up paywalls so that their subscribers pay for it. But another question is to what extent should those business entities that redistribute those things, the links, should they be the ones who have to pay, and pay usually by getting consent? So you can have some sites say we give free consent because we want to spread our ideas as widely as possible, and others saying no, you have to pay us for it. I'm inclined to say, from what little I know, is the Australian approach is not consistent with American copyright law, but it's an interesting intellectual property question in many respects, recognizing that intellectual property rules themselves are speech restrictions, which might pose interesting First Amendment issues too.
We have just a couple of minutes left, so I'd like to give Ro the last word.
Well, fascinating discussion. You can see why I enjoy chatting with Eugene. And I think, to the people watching, I would just say that, the way we end up thinking about regulations in a digital age, and the way we think about economic opportunity in a digital age, are going to be some of the fundamental challenges in the next 10 to 20 years. And to the extent people have an interest in that and are thoughtful about that and dive into the details of that, that expertise is sorely missing in Washington, and you would be able to make a very substantial contribution if you choose to go into a field like that.
Wonderful. So the life of a congressman is always crazy, and I'm willing to bet, Ro, that it's even crazier than usual this week. So we're very, very grateful for you making the time to join us.
Oh, I enjoyed it.
Thank you so much.
And it's been such an interesting and fun conversation. So thank you, Eugene. Thank you. A pleasure as always. The recording of this will be posted on the AI Pulse website within a few days, aipulse.org. Stay tuned for future events from the AI Pulse project. Thank you all for joining us. Thank you, Ro. Thank you, Eugene. And everybody have a great weekend.
Thank you very much.
Thank you again. Very much appreciated.
Thank you.
All right, Ed. Thanks very much for your keen moderation.
a little bit more active than I had initially expected, but there was so much interesting stuff to do.
Exactly. Very much appreciated.
Great, and thank you so much for setting this up. It's like what an interesting guy, and yeah.
Yes, he totally is.
Okay, take care. Have a good. Oh, I'm going to see you in a few minutes at a faculty meeting, right?
Exactly.
Okay. Bye-bye. Thanks.